everyone. My name is Bernie Wolfsdorf. I'm the managing partner of WR Immigration. Joining me today is my partner, Nate Groh. Nate is based in the Oakland office. I'm sitting here in sunny Santa Monica today. Our topic is the big one for many employers and many foreign nationals seeking to work in a specialty occupation, and that is an update on the H-1B fee, what employers need to know. I am pleased to announce that U.S. Immigration provided considerable guidance last week on the 20th, October 20th, and we're going to dissect that a little. I wish we could say everything is 100% clear, but their situation is fluid. But we are able to give you considerable guidance to help you navigate, particularly since we are now approaching cap season where you have to start planning for next year's H-1B lottery. Of course, that doesn't apply to the cap exempt folks, universities, certain research institutions, etc. $100,000 is certainly a lot of money, so we don't want to be getting this one wrong. Standard disclaimer, this is not legal advice we are giving you today online. We're discussing issues. If you are have legal questions, there's our general email number actually comes to me. Also, we will share with you Nate's email. There's Nate's email, ngrow, and Nate is one of our recently appointed partners, specializes with H-1Bs. There's my email address. I do like to confess that is a picture of me when I was a little bit younger.
Me as well. I've reconsidered the facial hair.
Indeed. Nate's
Time for an updated picture.
Nate's gone clean cut, and I'm using an old picture, but I think we're allowed to do that still. Pardon my weak sense of humor. A little bit about our firm, WR Immigration. We now have 10 offices. I believe we're over 200 people. The secret sauce at WR Immigration is our technology, which we try to combine with compassion and empathy, but Rapid, which is our proprietary immigration software, is, in my opinion, our distinguishing feature, together with compassion and empathy, which I believe is critical for the practice of immigration law. So let's briefly run through this proclamation. And I want to also define the word proclamation. What is a proclamation? From a legal perspective, you have statutes, you have regulations. Those are binding on everyone. And then you have proclamations, which really is an instruction to the executive branch. Well, pretty significant, because the executive branch are the folks who are adjudicating these cases. But it's not per se statutory law. It has to contend with actual statute and regulation. And of course, the United States Constitution, which lays out a groundwork. I'm not doing politics today. I'm doing H-1B. But I do want to point out that some of these proclamations survive and some of them don't. But as of the present time, we got hit on September 19. I say hit because pretty much everybody was blindsided and panicked about this critical change effective September 21. That was, we called it Freaky Friday, I guess, or some people have. And people had to enter before midnight on September 21, or potentially have a $100,000 penalty payment fee, let's just call it. And it's packaged as a travel ban for a reason. And that is because the president has had considerable success at the Supreme Court with travel bans. So this proclamation is quite skillfully drafted to focus on what has been for the president a winning ticket. So it was carefully drafted for people entering the US. It's a travel ban and tied to entry. That is a critical thing to understand. Now, it's supposed to last 12 months, but of course, the president does issue a lot of proclamations and can very easily issue a new one. The rollout has been kind of vague. It appeared to cover all H-1B workers, and there was panic about people being out of the US, and we were encouraging people to come into the US and not to travel and not to leave, and it was just complete chaos in the entire H-1B. So the rollout was incredibly stressful. I didn't get a lot of sleep that weekend. And there's still a lot of issues that are not clear, but there's a lot more clarity than what we had. And some of the more conservative advice we gave turned out to be too conservative. But the question is, can you be too conservative with a $100,000 penalty? Not many people can pay that. So this is the framework. We're trying to give you an update today. We are encouraging you to put questions into the chat. And I have asked Nate to butt in with questions as we get to the specific topic. And
the best place actually to put those in is the Q&A feature.
Thank you,
in
Nate.
Zoom. Yeah.
So please put your questions in the Q&A. Please try and keep them.
Some of you all submitted questions beforehand when registering. Thank you very much. And we are going to try to cover as many of those as we can today too.
Try and keep them short. And my favorite word is pithy, P-I-T-H-Y. Just not the whole speech, blah, 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 blah. Just what is the issue that's bothering you? And we'll try and give you some clarity. Although my anticipation is that we will address a lot of these. Now, let's open this thing up to litigation. The president has won on the issue of travel bans at the Supreme Court. The president does have authority to decide who can enter the US, and that's black and white. So, and quite frankly, makes sense as well, to some degree. But there are now two legal challenges. The first one was filed up in your turf, Nate, in Oakland, Northern District, California, October 3. Coalition of healthcare union and academic groups have filed claiming that this proclamation exceeds the president's authority under the Immigration Nationality Act and violates the APA Procedures Act, which requires, before you make rules, you notify the public, you give them a chance to comment. Otherwise, it's potentially arbitrary and capricious. That was not
Bernie,
done.
some have wondered, so there have been other Trump actions that got knocked out quickly in court with temporary restraining orders, and some are a little frustrated that these seem to be going slow. Can you speak to why maybe?
Yes, absolutely. Thanks for reminding me. So in the past, where people are immediately impacted, you can file for something called a TRO, temporary restraining order. So you see that, for example, in domestic cases, courts are very generous in granting TROs because there's a potential for immediate harm. Here, of course, you may think, well, there's immediate harm. Paying 100 grand is harmful to many, and many employers can't do it, particularly small employers. However, there is no plaintiff who is ready to stick their neck out. And for this reason, my understanding is there's no TRO, and there will more likely be a preliminary injunction if the judge agrees that this was arbitrary and capricious, pardon me, and that there was no adequate notice to the public and comment, which is how laws are normally made, pardon me, and implemented. So,
Do you think, Bernie, that that was maybe part of the strategy here for putting out this proclamation, making it look really broad, scaling it back through the clarifications? They've kind of eliminated in the clarifications the people that would have more urgent need. It seems like it's a little bit the litigation strategy.
Very well stated, Nate, and exactly that. The situation right now is this is in the hands of very intelligent Department of Justice lawyers, and it's a strategy game. And the clarification is designed in such a way to make it fall within the framework of the Supreme Court decision, where the court said, yes, that's within the framework of the president power. So there's a chess game going on right now, also called cat and mouse game, between the administration and the courts, or in the courts, to try and win this game. It is also, I can't tell you who's going to win. It's also possible that if there's a preliminary injunction, great, 100K fee would go away, especially for cap season, which would change the game, but it has spooked a lot of employers. What am I talking about? Well, I read that, I think it was Walmart, which had a big program, 2,400 H-1B foreign nationals won't be sponsoring. And quite a few people, and there's this whole thing, well, yeah, look, you know, what about US workers? And of course, US workers have to come first. So at the end of the day, this is a big political football. Some employers are moving forward. I predict, using my crystal ball, don't put money on it, that there will be an injunction, but I cannot predict where the Supreme Court or the appellate courts might go on this one. So
yeah, and in that sense, Bernie, the effect of this has been not the stated effect so far, right? Nobody's paid this $100,000 fee, and with the clarifications, we're going to talk about it further. Most people won't. There's going to be few cases where it applies, but the real effect has been in the messaging and discouraging employers and foreign nationals. You know, I have a client that was looking ahead at their cap next year, and this announcement came out. We pushed out the announcement that looked vague and very broad. And when the clarification came in, I circled back to them and I said, so your guys are going to be okay. We're going to do change of status for your cap cases, and you're not going to have to pay the fee. And they told me one of their engineers had already gone home, said, I'm never going to get H-1B, gave up and went home.
Yeah, chilling effect. And the chilling effect is a big deal. At the end of the day, the administration is very effective in messaging and creating these chilling effects on employers. Whereas, and I'm, again, not into the politics of this, but at the end of the day, the whole is greater than the sum of the parts. These H-1B people create jobs and contribute to the economy in a positive way, but let's stay off politics and focus on the nitty-gritty of what's going on with regard to this H-1B fee. Now, folks, for those of you who want to understand all of this, hats off to our team that put this together. This single slide provides clarity in 95, well, maybe that's a little high, in almost all the cases, and is a good guide for employers and foreign nationals. I expect this slide to start circulating. I don't know if it's going to go viral, whatever that means, but we did a presentation yesterday, Nate and I, at the National Association of Foreign Student Advisors conference here in Los Angeles, Pasadena, and clearly the audience loved the slide. In fact, we were asked if they could use it, and of course, we generously said so, provided, of course, you give us credit. Okay. Petition type filed on or after September 21. So let's call that new petitions. What is a petition? It is a form I-129 filed with USCIS. This is the process of obtaining an H-1B work authorization. And there's two ways basically to obtain an H-1B. Sorry, I'm keeping this basic level. You can file your petition and have the notice of approval sent abroad to an American consulate where the person will apply for a visa. That case requires a $100,000 fee, which, by the way, you can pay through pay.gov. Hopefully with your credit card, not mine. Bad joke. But at the end of the day, if you file, I use the word loose, what I call a loose petition, and you check the block consular notification, please break into your piggy bank and pull out 100 grand and give it to Mr. Lipnick, our Secretary of Commerce, because I think he came up with the idea, but I'm not sure. So, consular notification, 100 grand. However, all of the others, change of status. So if you're in the US in lawful status, on a student visa or OPT or H-1B, no big deal if the change of status is granted. Now, in order to get a change of status granted from F, you have to prove that you are admissible. Complex word. You haven't done anything wrong, broken any of the rules. Admissible. So, for example, if you've worked illegally or without documentation, whichever word you want to use, let's use it another way. If you're an Uber driver and you don't have permission to work, or DoorDash, I love those two things because apparently some people are doing Uber. They have a driver's license. They're not allowed to do that unless they have unrestricted employment authorization. So an F1 OPT, unless he's working for Uber the company as a trainee, I'm talking about Uber the driver, that change of status could be denied, and as a result, the petition could still be approved, but the person would have to leave the country, apply for a visa, and bingo, 100K.
Yeah,
So-
side hustles of all kinds now are always our advice is don't. Only work when you have explicit work authorization. But now, if you're working on your own startup company on the side, you formed an entity, that could be a risk with $100,000 consequence. Or if you've got an Etsy shop, if you've got any kind of side hustle, any kind of consulting you're doing on the side as a foreign national, and recognize that this is a risk, not just to foreign nationals, but their sponsoring employers, right?
So you really
got your side
need-
hustle, the cost is going to be to the employer that would have to pay that $100,000 fee if you're deemed to have violated your status.
Nate, perfect example, thank you, of somebody who has potentially violated status. Let's move into other area of inadmissibility. What if I have a DUI? Yeah, I'm a student. I went to a party. I got a DUI. I was pulled over. It's been expunged. I didn't got my punishment. I spent the night in the tank, my driver's license suspended, etc. Is that person now inadmissible? And is that going to trigger a denial on the change of status such that the individual employer would have to pay $100K? Nate?
Every interaction with police, even short of an arrest, raises additional concerns now like it hasn't in the past.
So the answer is it could be a problem. And at that point, it becomes discretionary. And you need to hire Nate to prepare a legal brief because he just got one of these approved. It was to an 01, but the fact that the individual had an arrest and a conviction resulted in fingerprinting and ASC, and we submitted a brief showing that that person was not inadmissible and was approved. Had it been denied and had it been an H1, the person would have had to pay $100,000 as a penalty. So the moral of the story is please don't drive over the speed limit, break the rules, and get yourself into trouble.
Yeah, and I think one of the biggest risks, the biggest place where we see maintenance of status issues has been for H-1B employees that have changes to the terms and conditions of their employment. And the ones most relevant are a change in work site, so a local move or moving, your H-1Bs for the office, you start working remote from home nearby, that's okay. But if you're moving outside of ordinary commuting distance, your work site's going to be outside of ordinary commuting distance from the work site or work sites listed in your H-1B petition, that requires an amendment before the move. Also, if you're going to have a reduction in pay.
Can I just stop you there on that one?
Sure.
Because I see a lot of those, ordinary commuting distance, I believe that's 75 miles. So, you send to the client site, and we're going to do a whole seminar on roving employees. But basically, if they're going to be assigned to another work site for more than, and I'm just going to say 30 days, but there's a 60-day exception as well. But if that person, so the managers need to talk to the HR, let you know. And why is that relevant? Well, because the job has to be at the prevailing wage. And the prevailing wage for downtown New York City may be higher than the prevailing wage in a more remote area where wages are lower. So the government's very focused on making sure that H-1Bs do not upset the job market. And in fact, they've set the prevailing wage, which is a median wage, quite high to help lift wages up. H-1Bs don't suppress wages, they lift wages because they have to be paid a median, which is a Department of Labor wage. But Nate, thank you for pointing out that the situation with an amendment creates problems or potential problems, because if you have violated status, immigration wants to see the pay stubs, they see you at a different work site, you file your AR-11 change of address form within 10 days, failure to do so is a federal misdemeanor. So, the bottom line is you got to change the address, but you didn't file an amended petition. So back to you, Nate.
So what you want is messaging through your company to H-1B employees, managers, and of course your global mobility, your HR, immigration consultants need to be aware. They need to be flagging well in advance of planned job changes. The worksite change, also a significant change in job duties. A promotion where you're just changing your title, you're getting a raise, and your duties remain largely the same, not a big deal. But if your duties are really going to be changing, or if you're going to move from an individual contributor role to a managerial role, or vice versa, then you need to make Immigration Counsel aware of those changes as early as possible and file an amendment before that change becomes effective.
Material change. Nate, you were recently promoted from senior attorney to partner. Is that a material change? If you were on an H-1, would I have to file an H-1B? I don't know the answer to that. It's kind of on the verge, right?
It could be. You have to look at the change in the job duties for anybody who's undergoing a transition in their role. And keep in mind, it doesn't have to be all at one time. If somebody's role transitions slowly over time, such that you'd look back and you say, you know, those job duties listed in my H-1B petition, just slowly over time, I rolled from doing that to doing very different things. You need to be careful of that kind of transition as well.
So location, promotion, all of those are potential triggers, and it somehow gets to the point of material change. Again, the point is, if you didn't do that, you can end up with a loose approval and it's necessary to file an amendment. And very often what people will do is do both. They will amend and extend. So we started off talking about the change of status from F to H, or in some cases even J to H, or even a B to H in some cases. That may be permissible, but if there's been a violation of status, this triggers the 100K. While we're on this, just little tangential, in your opinion, can the foreign national pay the 100K if they wanted to, if they were super rich? There's this issue about whether or not foreign nationals can pay government filing fees. And up to now, they've kind of said no, right?
Yeah, well, clearly there's clear regulations around other H-1B fees, legal costs, filing fees for your H-1B. Employees are not supposed to pay that because, in essence, that kind of messes up the calculation of whether they're really getting paid the prevailing wage. If they have to pay the cost of getting into H-1B, then their wage is essentially lower.
Thank you. That's the Department of Labor interpretation. So that filing fees are supposed to be paid by the foreign national because it's part of the tools, strange word the Department of Labor uses, it's part of the tool to do the work is the visa. Therefore, if the foreign national is paying it such that it reduces the prevailing wage. So the prevailing wage was 100 grand. Now there's an argument, well, actually, the foreign national is earning zero because, and that's upsetting the job market because they paid the wage. Sorry, we won't go down. I want to touch on the bottom one, change of employer. So I have an H-1B with employer A. Unfortunately for me, I just got laid off. Amazon is apparently laying off 30,000 people. There are layoffs. It's very sad, very difficult, very humiliating. But the good news is Apple or OpenAI has offered me a job and I want to file a new H-1B. What are the problems that I'm going to face now, Nate, with the Department of Labor being closed because of the shutdown? What are we at, 25, 26 days or something? Almost a month already. You can't even file the critical LCA, labor condition attestation, which is step A of the process. What sort of problems does that present for you? And what are the solutions, Nate?
Yes, very tricky. This happening while also we've got this government shutdown. You can't file any LCAs. There's a couple of questions in the Q&A about this. Thank you for submitting. Yeah, that makes it an even trickier question because in some instances here, you know, you need to file an H-1B as soon as possible to avoid an issue with maintenance of status, but then you can't get an LCA. So what do you do? And some people are asking, you know, what does this look like? So the situation is just happening now. We don't have a lot of
Well, I'm going to
hard
give some
examples.
answers because the way I was trained as a lawyer is never say on the one hand you can do this, on the other hand you can do that. We only want one-handed lawyers in our firm. This is what you need to do. Of course, there's two options. Sorry, being like a little rude on this, but my preference is that if the person is getting to the point where they are going out of status, because out of status now triggers a new word called, or phrase, called NTA. Notice to appear in front of an immigration judge for a deportation hearing. Terrifying, terrifying experience for a foreign national to have to go in front of a judge and face potential deportation. So my advice would be to file it with an uncertified LCA. Just put it in, explain it to the government, always be upfront, say, you know, we don't have a certified LCA because the government's closed. Here's a copy of the LCA. We promise to comply with all these requirements. We've posted this for X days. We've done all the rules. We're just unable to file this. Please accept this case. And I would not file at premium processing, which triggers a 15-day adjudication business day. I would file it. And if you get the receipt, the current regulations allow that person to port under AC 21, American Competitiveness Workforce Improvement Act, to commence and be employed for a period of up to 240 days, 10 months. So the mere filing of the petition, but be aware, if the government finds a status violation, now there is something called non-pro-tunc, NPT, all of you Latin scholars, retroactive. The government has authority to retroactively approve that H-1B because of circumstances beyond the control, extraordinary circumstances beyond the control of the employer or the foreign national. Well, the shutdown is clearly beyond the control of the employer and the foreign national through no fault of the employer or foreign national. And in the past, they've been moderately generous on issuing non-pro-tuncs where you meet these circumstances. Other people are saying, well, you know, just let them go out of status and then file. But if you get an NTA in the meantime, that gummies up the works, because USCIS won't adjudicate or may not adjudicate if jurisdiction is now in front of the immigration judge. You got to get permission from the judge. Sorry, back to you, Nate.
So, Bernie, you're saying if a current H-1B employee with their company needs an extension, file it now. Don't let it lapse and then just rely on non-pro-tunc.
You got it. That's my clear advice on this one is, okay, you can't file the LCA. I don't care. Fill out the form, throw it in, explain it to the government why, and again, don't do premium processing, and then hopefully you'll get an RFE, or alternatively, when DOL reopens and issues the LCA. But remember, when they reopen and issue the LCA, that LCA certification is not going to cover the gap period.
Right.
Why? Because LCAs can't be retroactive. So the government has to sort of turn a blind eye, and that's why I say just put in a statement, I the employer, or we the employer, hereby agree to follow all the terms of the LCA for the period A to B, but you don't have the certification. So at the end of the day, it's not a real LCA. It's an uncertified LCA, but the government does have the authority in the regulation to do non-pro-tunc. A little bit complicated here, folks, but end of the day, I am just banging this drum. Please don't violate status. Please don't break the law. You know, any criminal act, you know, an arrest, a conviction, are all sort of triggers. So foreign nationals, please be careful. Don't break the rules. If you've broken it in the past, this could be a little bit of a judgment day for you, because that issue could come up. Unauthorized employment, use of inappropriate substances, banned substances, etc., can all be an issue in regard to maintenance of status. And Nate, they're also looking at security issues right now. So, you know, if you are an activist and you want to be an activist, I'm not telling you what to do, but at the end of the day, they are looking at things like social media and postings, which the government may feel is a security interest. And again, no politics here, but I'm just pointing out the type of activities foreign nationals need to be careful, who they're supporting, and what they're posting online, what rules they break, because it works directly into this clarification that if you change status, extend stay, amend status, or even change of employer, you're okay. But if the change of status, so when you file this I-129, there's kind of two applications. One is to change your status, and the other is to be converted from your current status to the existing status. That is the second part of the application, which now has become so critical, because if it's not approved as a change or an extension or as an amendment or as a change of employer, and you go from no fee to yes fee, and you're $100,000 out of pocket, which, Nate, let me ask you a question. So let's suppose I just won the lottery or my employer did, and they want to pay 100 grand, or they're making so much money they don't really care. They amortize it and say, well, that's only X numbers of dollars a year. Is this a one-time fee? So if I pay it and 3 years from now they extend this, is it possible that it'd have to be paid again? Or we don't know?
Well, the way it's written, first of all, is that it's 12 months. It's only effective for 12 months, although, as you mentioned, they could extend it. And the way it's written is if you've got H-1B and you're going to extend it, then you don't have to pay it once. If you're going to do multiple consular H-1Bs, first of all, you seem to have a lot of money to give away. Let me get a job from whoever wants to pay multiple $100,000 fees. But you should be able to strategize to not pay the $100,000 fees for most, or if not all people, right? Don't pay it for anybody, but if you have multiple consular H-1Bs that you're looking to file, then it's possible you're going to
So
pay.
Nate, let me ask you another one. I fairly recently filed for a dentist, licensed dentist, H-1B. Dentists often work in multiple practices, apparently. This gentleman had 3 H-1B employers.
3 concurrent H-1Bs?
Yes, sir. Is that
Are they consular though? Don't do consular H-1B.
I'm building the hypothetical here.
Okay.
So it's a hypothetical. We're going to hire a Canadian dentist. Apparently he's amazing. And he's got, well, to make it simple, 2 job offers in the US. He wants to do concurrent employment. Would you just file that as a single H, and then when they're in the United States, amend to a second, or would it be 200? How would you strategize that?
Well, we should skip forward to our alternatives. People are asking about this too, but the dentist, it's got all that kind of clout. Everybody wants that dentist. Maybe you need to be thinking about 01 and not
thank you, Nate. I actually like that answer, because it's a gray area at the end of the day. You could file it with a single employer, part-time, 20 hours a week, and then amend and extend in the US and avoid the 200K. So a lot of strategies here. But Nate, I do like your answer. If indeed the individual is eligible for an 01 as an extraordinary ability individual, but you have to meet the designated criteria, high salary, key position, press about the individual, acclaimed, an extraordinary ability person. So you also say, well, let's look at the alternatives. I'm going to be respectful of people's time. I've sort of been on the slide for quite a while. So we've been talking about these issues in some depth: common main overstays, criminal, H-1B, et cetera, apply for a visa board. This is the summary of what we were just saying in real terms, material change. Thank you for the excellent summary. These are the red flags that employers need to be aware of, and your foreign national employee may not come and tell you about the DUI. So kind of becomes a little bit of an issue. Sometimes we only find out when we get the request for evidence. So we need to be asking these questions.
Somebody in the Q&A asked, should employers be asking their foreign nationals if they have side jobs?
I think so.
I don't know about directly asking, but all employees could use a reminder, a blast email, a handout to employees saying, this is how you make sure you do not have an issue with maintenance of status. If any concerns, talk to us, talk to Immigration Counsel.
And sometimes you could even have conflict issues, right? Between if the foreign national's conviction involves moral turpitude, which relates to inadmissibility, how does that impact the employment, et cetera, et cetera. So we're getting quite complicated, but this phrase, maintenance of status, is really what our presentation is all about today, because that's the key thing. So strategies for employers, Nate, you very correctly, I want you to run through these, please, and outline again, because you've already mentioned some of them, some of the strategies that you're recommending to employers.
Right. So most of our clients, when they're sponsoring H-1Bs, it's either through the lottery for somebody who is already here, like F1 or another status, or it's a change of employer for somebody who is in H-1B status in the US. So it's simply not going to apply, right? If you have people that are outside the US and they can get to the US in valid status, they should do that to avoid the fee, first of all. File your H-1Bs as change of status, extension of status. Don't do consular. That's number one. And then, if you are hiring from outside the US in a role where you might have considered H-1B, maybe they had an H-1B prior and they could get back into H-1B status. So that's a $100,000 fee. You got to start thinking creatively, start thinking around other options. Could they qualify for J1? Could they get to O1 extraordinary ability? O1's, the standard has not gone up so far. It very well may in the next year, but it has not yet. We've always advised people, get to O1 eligibility. It improves your outlook in general, right?
For self-sponsored petitions and green cards, EB1, NIWs, but it's not a pure dual intent visa like the H-1B. So we also like the
True.
And Nate, talk about this J1 research because it's a limited situation, right? There is a J1 research category up to 5 years, but that's a non-immigrant category. You've got to prove you're going to go back home. And of course, it's part of the international exchange program. So, but
it's not ideal, but if $100,000 for an H-1B is a deal breaker, then you need to consider the other options.
But if you're not engaged in research or research scholars, mainly for universities,
you could be a trainee. You could be a trainee.
Good point. So it could be a J1 trainee, but I don't think the government looks fondly on H-1B positions that are sort of repackaged as J1s. I think they're more comfortable with O1. So let's go on to, now we had something, it happened a few years ago. Let me think, what was that called again? COVID, right, COVID-19. I remember that one. I guess we all forgot about it. Except it's still around, but not the same one, I think. So we during COVID, there were health concerns and travel bans, which made a lot of sense. We didn't need new bugs. We had enough of our own bugs. Stop being silly, Bernie. But national interest waiver needs. And Nate, I know during COVID, you filed tons of these needs, national interest waivers, and they all got approved, and it was really easy. And you applied to the consulate. This is different.
Yes.
The knee here is not something you apply at the consulate. The knee here gets submitted to DHS through an email address, and you need to get that before you file to avoid the 100K. And then, and the government has come out with guidance, and gosh, this guidance is very, very clear, using the word extraordinarily rare. This is not the same one that we had under COVID. So in order to get an exemption, you file with DHS and you meet these criteria, all four of them, not one. Number one is in the national interest. That's a very broad phrase. And by the way, again, no politics, but that has changed from the prior administration. Prior administration, they like green energy, entrepreneurship, other good things. Now the focus is different. What's the new buzzword on energy, by the way, Nate? I forgot already. Energy independence. Energy independence, and I'm not
reliant on foreign sources of energy. We need more diversified energy sources in the U.S.
Well, again, we don't argue with those. So that's changed. But not to digress, we have to show there's no American worker available. That is very often the case for H-1Bs. They have to be kind of unique positions. So if it's a routine. Number three, no threat to security or welfare. Again, those used to sort of, that means something because they will do background checks on you, make sure that, you're acting in the US best interest. And now this other big one, payment would significantly undermine the interests of the United States. Very vague. So you have to meet all four of these criteria in your NIE with DHS in order to get an exemption, and your chances are slim. But maybe if there's critical research that's in the national interest, I picked up this framework this is something I picked up, national interest. Three buzzwords: make America stronger, safer, and more prosperous. I don't think we can quibble with those. They're pretty good ones. Who doesn't want to make America stronger, safer, obviously, and more prosperous? Well, yes, of course, we want to create job opportunities. So that's the thrust of your NIE argument, in my opinion. Not that my opinions always count, but I'm just saying this is something that has been stressed by the administration, the three new buzzwords: stronger, safer, and more prosperous. And I think a lot of people think that makes sense. Back to you, Nate, on waivers. Are you all teed up and ready to go for a waiver?
Well, there's nothing wrong with trying in my book. Like you said, Bernie, the standard is very high, but we have clients that have employees that would fit all of these. And so nobody's looking for opportunities to pay an extra 100,000. Sure, maybe some companies can afford it, but why not avoid it if you can?
So what if you were an engineer working on a drone project, and you had some sort of critical role, is that going to make America stronger, potentially safer, and more prosperous? Yep.
It's got room for a creative argument. And, if you're a company that has sponsored a bunch of perms for same or similar positions, you've already got evidence that no American worker is available. Do you want to throw that evidence of your perm program into an NIE and highlight that you've got an effective perm program? That's up to you. But
we've been looking for a qualified dentist for the past 3 years. We can't find anybody. Good news is we got this Canadian specialist, and have a shot. I think some of the areas that sound interesting to us, universities doing critical research, advanced research, that sounds interesting to me. Sensitive areas where America, would help create robotics, AI. I mean, it sounds to me like there's a lot of options for political, but I think, it's going to be very, very hard. And I think you're going to have to sort of reach out to your government relations people and make arguments that this administration would feel compelling. There is no further guidance. This is all new stuff. But I do have to tell you, this is not the same flavor as the knees that we used to get during COVID, which were, quite frankly, very generously granted. I think we were scoring 100% on those. But I do encourage employers to look at this, evaluate it in terms of meeting all four of these criteria. And if you think you've got it, and what are you going to do? Call 108 and run it by him? So, Nate, thank you. Recruitment evidence. You spoke about the support letters, unique qualifications, labor. What if it's a Schedule A occupation? For example, nurses and physical therapists have already been determined by the US Department of Labor to be in national shortage. And I think nurses, doctors in underserved areas. It's a Conrad case. For many of you don't know this, but I believe there's a old statistic of like 70-80% of doctors in underserved areas are physicians on H-1Bs, most of them from India. So yeah, we want to kick these guys out, and then who's going to do the healthcare? Or how will that impact the cost of healthcare? So I think doctors, researchers, universities, but also critical industries. And we've been doing Q&A all along, but Nate, because of my incessant babbling, I may not have given you enough chance. So more questions, Nate.
Yes. What about the complexity? This is from the Q&A. What about the complexity of someone who is subject to a non-compete that extends beyond the normal 60-day grace period? Is it better for that person to try to switch to B in the US and then file an H-1B later and change
Oh.
back?
We were arguing about this one earlier. Firstly, sorry, as a lawyer, like in the state of California, non-competes are illegal, effectively. I mean, maybe if you got paid $10 million or something. So, examine whether that non-compete has any. But Nate, you were saying earlier that you've previously done change of status to B1 business visitor,
Yeah.
or possibly
Where it keeps
B2.
coming up is our corporate clients want to hire somebody who's been laid off somewhere else, and they are past their 60-day grace period, so they filed an application to change to B status. To date, we have had success with file a premium processing H-1B change of status, and that seems to speed up the adjudication of the change to B, and then they change them right back to H-1B.
Past performance is no assurance of future results. I know this is not a
Exactly.
securities lecture, but I think, Nate, you're pointing to something that I don't want to like count my chickens till they hatch, but USCIS has not always been unreasonable in looking at these facts. And
You know where
actually,
we found that they seem to be more reasonable. You almost don't want to say it out loud to jinx it, but online
Yeah.
filing H-1B premium processing has seemed to be more reasonable than mail-in premium processing lately.
Well, then I'm going to give a plug for Rapid, which is our technology system, because one of the distinguishing features about Rapid is we're doing all our filings online, automated with the press of a button. And I understand very few firms have this capability of doing online filings. A lot of firms, in fact, are struggling with it. I was very excited in the cap season this year. I think we did like all of our H-1B filings in about an hour or so. Everything was loaded up and bingo, press the button. But all right, stop bragging about Rapid. Nate, this is
Bernie, here's a good clarifying question. Back to our what do you do with this shutdown and an H-1B extension? Somebody asked. So we can file an H-1B extension petition without an approved LCA. I don't think you were saying, Bernie, were you, that guaranteed you're going to submit your petition without an approved LCA and it's going to be approved. You're just saying that's the recommended approach over letting them lapse.
exactly. Thank you for
Yeah.
clarifying, Nate, because at the end of the day, I just don't want a person to go out of status. So it's kind of like scary. I think we should almost have clients sign a waiver because I'm advising people to file a deficient application. And if the government decided to reject it because it was filed without an LCA, please don't sue Bernie, sue Nate. Stop that. Please don't sue us. Nate and Bernie are the same thing. Except he's probably smarter than me, is smarter than me. And bottom line is, I'm recommending the strategy that it is better to try and show the government that you're trying to comply than, because everybody's aware of the shutdown right now, obviously, but maybe, a few months down the road, they look at it and it's like, what shutdown? Like, what COVID? They forget there was a crisis and you didn't have your LCA when you filed, and you didn't want to pay premium processing because you got AC-21 porting, and it's 4 or 5 months later. And question is, has your person been out of status? Nate, what if it's 180 days? What happens if the foreign national is out of status because you did not file anything? You did not file the B, you did not file the H, and for some reason the foreign national is now at 180 days. That triggers a
bar for
Three-
the US.
3-year re-entry
3-year
bar.
bar.
So you kind of pinned in here, folks. The stuff is complicated. We're looking at entry bars. We're looking at inadmissibility bars. We're looking at $100,000 fee bars. And yet, Nate, I feel quite good about all of this stuff. I actually think that it's primarily business as usual as soon as they lift the shutdown, which hopefully will be very soon. Congress will come to its senses and do the right thing. But in the meantime, it's added salt to the wound because
Yeah.
coming at this particular time, the shutdown is extremely unfortunate for H-1B employers, but my hope is it'll be resolved next week. We're back to business as usual. And I'm telling employers, go for it. There's no big deal. The only thing you need to make clear to foreign nationals, even though there's been clarification it's safe to travel, is we are not yet ready to say, oh, it's safe to travel. And yet a lot of our clients are ignoring us. Yes, I understand you have that wedding. Yes, I understand you have a family emergency. You're going, but I don't want to be in the situation where the lawsuit is lost and the government decides to become a little more aggressive and impact people who are abroad and give new guidance, because the initial guidance was clear like mud. This new guidance is much clearer, but I wish I could use the word crystal clear. And we're a work in progress, Nate. We're probably going to have to do a part 2 to this webinar, but I see we've been going for close to an hour. Give me one or two last questions.
Bernie, just on your point there about you're telling people keep going forward, keep filing your H-1Bs, just reporting from what we're seeing among our clients. So, I think there are some companies that their practices are a little more public and they're concerned about the optics of H-1Bs. And there are perhaps some companies that are scaling back, but the larger part of my clients have not slowed down on their H-1B recruiting and hiring, paused because of the shutdown. But we have a lot of change of employers in the pipeline and companies that still want to go forward. Number one, because they need the workers, right? They don't have alternatives to fill these roles. And number two, because despite all the attacks, there is confidence that so many of these they're going to get approved one way or another. We've got the clarification now that the fee is not going to apply. The advice is be more cautious. Make sure you've got some good advice when you're filing H-1Bs now. Make sure you've got maintenance of status. But if you do, then you're going to be okay. Your extensions, your change of employers, your amendments they're still going to be approved, assuming the government ever starts.
And Nate, that's really where I'm going right now. The government has scared a lot of people away. But at the end of the day, I don't know that I've found the employer who wants to pay all these filing fees and legal fees when there's a qualified American available to do the job. There's a reason why they're doing it. It's not like, well, we prefer to hire people from here or there. The fact of the matter is that there are cutting edge. I think it's 65% or close to 70% of the H's are in technology, and many of the others are in healthcare, where there are serious shortages. And employers are doing this because of critical need, not because they love going through the H-1B process and paying lawyers and government filing fees. There's a real...
Plus in the perm process, plus waiting years and years, Indian, Chinese nationals backlog. Nobody's asking for these headaches. They do it because they need the workers. There are no alternatives.
They critically need the workers for their advantage. Has there been abuse in the program? There isn't a program in America that doesn't have some abuse. But I think the statistics are relatively small. Those of you who are planning to abuse the program don't, because there will be more investigations and audits and compliance. But for those of you who do not drive over the speed limit and break the rules, the H-1B program is a good program. It's a viable program. And a lot of the great success we've seen in the United States in technology, in artificial intelligence, robotics, medical research, would this have happened without the H-1B? So somebody's got to stand up and fight for this program. I'm not the advocate, I am the lawyer, but I want to tell you, and employers know this, who've used this, those people who've abused it, stop, because you're hurting everybody. And this is a good program. I believe it will survive. I do believe that Congress gets this. but the administration is tightening up and it's messaging quite well with the public because, the job market has certainly got more difficult, but the people coming in are in generally very narrow categories, performing specific. All right, Bernie, you're over an hour. Nate, thank you for putting the PowerPoint together. Folks, you got questions, email us at ngrow@mylastname.com. Copy me if you want. There are the individual offices, Boston, Denver, Los Angeles, Santa Monica, New York, Oakland, where Nate is, Shanghai, etc., San Diego. The Michigan office is global, meaning outbound only, but wonderful to speak with you all today, and hope that you found this useful and that we have some clarity on the H-1B scenario, particularly when the shutdown ends. It should be even clearer sailing. So thank you, Nate, and until next time, we will do a part 2 as we get more clarity on this. Wishing you all a wonderful day, week, month.
Someone's asking if the recording or if we'll be sharing later. Yes, I think so. I think this will be available on YouTube.
Yes, the recording will be available. This will be on YouTube, and it will be pushed out through our LinkedIn, etc., etc. So hopefully you've got some clarity. But that single slide is the big one. Maintenance of status is the other big one. And I've said
someone is asking, when is our shutdown going to be over? If we had that kind of crystal ball, I'd be gambling on college football and I'd retire from this gig.
I don't gamble. I really think that the suffering of federal employees is unacceptable. Our soldiers on the front line not getting pay, unacceptable. Traffic controllers, we've got holidays coming up. These people are at food banks. Honestly, it is infuriating to me as an American citizen that we can't fix this problem. And please, folks up in Washington, start being a little bit level-headed. Think of the American people and the federal employees and the impact on the economy. But I said 3 times I'm not doing politics. So have a wonderful day, everybody. I anticipate within a week or 2, the government will be up and running, and then they're going to play catch up. But hopefully this will be resolved soon. Thank you, everybody. Have a wonderful day. And until next time, we look forward to updating you on all the latest developments.